All right. So welcome today to Providing Accessible Legal Services, a webinar that is much needed, not only for us on a personal level, but in our professional lives as people who provide services to people who have disabilities, and inclusivity should be at the forefront of everything that we do. For those who don't know me, my name is Alexis Alvarez. I am the Director of Training, statewide training at Florida Legal Services. And today I'm very excited to bring to you this webinar, not only because of the amazing group of speakers that we have here today, but also because it is co-sponsored by the Public Interest Law section of the Florida Bar, which for those of you who don't know, is a great network of public interest attorneys who are passionate about the work that they do and create a great network together. And this wonderful lineup of speakers that we have was curated by Disability Rights Florida. So we're in for a really great one today. Some housekeeping announcements. The CLE credit for this training is still pending. I will be able to get you that CLE code as soon as it gets processed by the Florida Bar. I'm going to put my email address and my phone number and everything into the chat. Anyone that wants to reach out to me just to check up on the CLE status and to ask me what's going on, please don't hesitate. It's my absolute pleasure to connect you with your professional development and your CLE credits. Second piece of housekeeping announcements, questions and answers. Please add any questions or answers that you have into the chat or the Q&A. I will be monitoring that. I think all of us will try to monitor that and answer them either at the end if time permits or if there is a moment that it is most appropriate. And additionally, I do want to say that we do have an ASL interpreter scheduled to be here today. We are also supposed to have live captioning, so I'm going to figure out what's going on with that. The ASL interpreter should be joining us, and as soon as the ASL interpreter joins us, I will pin the ASL interpreter to the screen, so you all should be able to have that accommodation. If anybody needs any additional accommodation or anything that I can provide, like I said, I'm going to put my email address into the chat and my phone number. My email address is Alexis, Alexis.Alvarez, Alvarez @floridalegal.org, and my phone number 407-553-2075. I'm going to put that into the chat, and please feel free to reach out to me directly. So I'm going to have to go forward with the introductions without the closed captioning. I have no idea why it's not on, and I really apologize. So I'm just going to move into those introductions, and again, I apologize. I will do my best to get this resolved. Today we have three speakers with us here today. We have Marilyn Yuzdavanes, a professor of law at Nova Southeastern University Shepherd Ford College of Law. She primarily teaches in the area of healthcare practice and regulation. Her scholarship explores the regulation of developing areas of medical practice. Professor Yuzdavanes has spoken at numerous national academic conferences throughout the United States, including the Society of American Law Teachers Conference and the Health Law Professors Conference. We also have with us Mira Gontes. She's a public policy intern at Disability Rights Florida. She is currently in her senior year at Florida State University and involved in the Coelho Law Center Law Fellowship, which is an international fellowship in disability law. Her goal is to become a disability rights lawyer and pave the way for future students with disabilities to grow during their education and succeed in pursuing their own employment opportunities. And finally, we have David Feldman. He's a licensed clinical psychologist and associate professor of psychology at Nova Southeastern University. He is the coordinator of the clinical forensic psychology concentration and teaches across several programs. Dr. Feldman is a graduate of Gallaudet University, the only liberal arts college for the deaf in the world, and has provided clinical and advocacy services to the deaf community for over 20 years. He has published extensively in professional journals and presented at local, state, and national conferences on the topic of deaf-related issues and accessibility. And so with that, I'm going to turn it over to our speakers. And in the meantime, I'm going to work on the closed captionings. And this is being recorded. A copy of the recording will be provided to everyone who is registered, regardless of your live attendance. And what I will do is, if I can't get the live captioning up, I will manually make sure that those are added myself. So that way everybody will receive this recording with the captions available. Thank you for your understanding, and I'm looking forward to learning with you all today.
Good afternoon, everyone. Today, we're going to be starting our presentation on providing accessible legal services, which is presented by the PILS Disability Work Group. First, we're going to start off with discussing universal design. Why is it important? First, we're going to be talking about Chris Downey, who discusses his perspective on universal design. It's one thing to provide an accessible space. It is one thing to provide access into space, yet quite another to provide access into a larger agenda of architecture. Architecture at its core should be the experience. It's important for us to design for delight in architecture when it is not seen or not heard when viewed for a seated position, and with the view of a vanishing line setting a lower height, or how it is experienced throughout the stages from childhood to senior years. And I think regarding this quote, it's important to think about how we design and make our spaces accessible. Chris Downey is a blind architect and talks about from his own perspective. And this is a quote taken from Rabbit Hole, Unexpected Tea Parties. To discuss what universal design is, it is about designing an environment composed in such a way that it can provide access to anyone regardless of what their age is, what their size is, or what their ability is. It's about being proactive on inclusion. This goes for any educational resources as well as building the environment itself. And it also includes buildings, products, services, and make sure that they are designed to meet the needs of anyone who uses it. Why does your law office need to be accessible?
Hi, so in this section, Mira was talking about what we mean by universal design. In the next few minutes, I'm going to be talking about why it matters that your law office is accessible. So there's a few reasons why. Number one, it's required under the law. So Title III of the ADA, as well as Title II, and we'll talk more specifically in a few minutes, as well as widely recognized international guidelines and principles, all support making access to justice accessible for people with disabilities. We know fundamentally that the justice system plays such a critical role in engaging in society. Additionally, laws, practices, procedures are still continuing to discriminate against people with disabilities. If people with disabilities do not have access to legal representation, then they aren't able to try to correct some of the wrongs that are still continuing to go on in our society. In addition to that, just being able to access conflict resolution and a wide array of legal services, you need to have access to an attorney, access to the justice system. So moving on to the next slide. As I mentioned, this international principle and guideline for accessibility for persons with a disability states that facilities and services must be universally available to ensure accessible access to justice without discrimination for persons with disabilities. Now, this was by the United Nations in August of 2020, where they promulgated several principles that support how important it is to have access to justice. And as attorneys, as we have our law offices, we're looking at what policies and procedures do we currently have in place that might be preventing that equal access to people with disabilities to have representation and fully enjoy the services that we provide. Next slide. So if we look at it in the United States, we have the ADA Title III that I'll be focusing on for this particular audience, but Title II, which deals with local and state governments, attorneys that are working with local and state governments also have the same responsibility under Title II. But for private offices, it's Title III because law offices are considered a place of public accommodation. So I'm going to read the language that is here on the slide, the implementing language for Title III. It says, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. So important terms in the statutory language here: discrimination. What does it mean to discriminate? And on the basis of disability. What does it mean to have full and equal enjoyment? And what is a place of public accommodation? So those are some really important terms that are embedded in the language. Well, discrimination, if we go to the next slide, discrimination looks like failure to accommodate someone who's asking for accommodation and has a disability. It's already been established that law firms are places of public accommodation. So when we look at what does a person with a disability need in order to fully and equally enjoy the services that you're providing or benefit from the services that you're providing, they'll need an accommodation. And if they're requesting a reasonable accommodation, if you fail to provide it, you are discriminating. You're discriminating and violating the ADA in Title III here. So what is reasonable? Of course, details matter, but thankfully you don't have to figure out on your own what's reasonable. The Department of Justice has issued a good deal of guidance on our very standard typical accommodations that have been requested. And so they've given implementing regulations regarding ways that you can accommodate certain disabilities so that you are not running afoul and discriminating. Now, there are a couple of defenses that are available to a business that is saying, well, we can't provide that accommodation, but they're very rarely successfully used. One is the undue burden defense, where the court will look at very specifically into your law firm. It's a very fact-intensive defense that you'd have to prove about how profitable is the firm, what is the particular accommodation that's being requested, how expensive is it, how is that going to unduly burden your practice. So you can't just say it's a burden, it's an expense. That's not enough. It has to rise to the level of an undue burden. And when balancing those two interests of the person with a disability and the law practice, the court usually errs on the side of inclusion. So you're really going to have a high threshold to try to claim it's an undue burden to make that accommodation. The second defense, which is even more rare in a law firm context, is a fundamental alteration. So if the firm were to claim, if I were to provide this accommodation, it would fundamentally alter the nature or the service that we're providing, then a court may grant that defense. But again, incredibly rare in this context that we're talking about here. And so the bottom line is you have a responsibility to provide an accommodation so that the person with a disability can have that full and equal enjoyment of the services that you offer. It's not enough to say, well, there's some access. We get some of what you're trying to explain here, where there's some opportunity. It has to be full and equal. And that's a really important concept, especially when we're looking at what attorneys do day in, day out. If we could go to the next slide. In order to prevent discrimination, we need to remove the barriers to access. So when we think about barriers to access, there's a couple of things that come to mind. The first is probably most of us think of a physical barrier. And this can be from the parking lot to the sidewalk, to the entrance, to the door, to maneuvering through the office and the restroom. We're all very familiar with having wheelchair accessibility. In addition to the federal law, there's state and local code that talks about having an accessible space, right? So any physical barriers, if you need to create a ramp or widen a door, those have to be completed. And so there's, specifics that we're not going to get into in the short time we have here today, but readily achievable barriers need to be fixed so that people with disabilities can have access to your firm. But when we think about digital barriers, are there digital barriers? Do you have a website? Is that website accessible to people who have disabilities? So there are some circuit splits going on right now across the country, but in the 11th Circuit, it's clear that multiple courts have held cases at the lower courts in 11th Circuit that your website has to be accessible to people with disabilities if it has a nexus to a physical location. So we know, especially after COVID, how much we rely on the internet and business websites to first engage that business and determine, is this somewhere we want to go? Or sometimes the entire transaction is through the website. That has to be accessible. So that's also a pretty solid law here in the 11th Circuit. And then when we look at the final piece, which I think is so critical for attorneys, is the communication barriers. Are there any barriers, communication barriers, for you understanding that client? We know as attorneys that the entire case, your representation, can hinge on one sentence and understanding exactly what your client is telling you. And vice versa, they need to know exactly what you are explaining to them as it pertains to their rights or their opportunities available to them. So clear communication is paramount when we're talking about representing your clients. And so the law, again, through the Department of Justice and their implementing regulations, has had effective communication regulation that says there are auxiliary aids that you need to provide and additional services. So people who have vision disabilities, hearing disabilities, speech disabilities have that clear communication. This is one where your client will not get the same level of service as a member of the community without a disability if they have a barrier to communication. So to get that full and equal enjoyment, you need to provide the auxiliary aids and services that will allow them to have clear communication. Next slide. So this is a requirement, as I said, under federal law, but it is a win-win for everyone. It is a win when, as a society, we are inclusive. Every member of our society is able to access the justice system. We see this with people who have economic hardships, with opportunities for legal aid to represent them, and across different facets of trying to make sure everyone has a voice and has access to justice. So here, as an attorney, as someone who's taken that oath of admission, where we say we're going to represent the defenseless and the oppressed, it is a responsibility and a way to make sure that we all have doing our part to make sure we're inclusive for people with disabilities. But it's also a benefit to your practice. It's an opportunity to expand your client base. So as you transition your practice, if it's not already, to be an accessible practice, then you're going to have an expanded clientele opportunity. You're going to have, word of mouth is going to travel. I went to this office. They were so helpful. They had this for me. I gave them a day notice and they had an interpreter. Whatever it is that you did to make that client feel valued and accommodated, that's going to help your business grow, because there's an entire sector of our population that's struggling with disabilities. And when they know that you have a welcoming office, that's going to help you expand your practice. And then finally, there are tax incentives. Now, this is not a tax CLE, so I'm not going to give you all the specifics, but there's two at the top of my mind here. There's a deduction for businesses that remove barriers. So if you do include a ramp, if you widen a door, all businesses have the ability to take a tax deduction up to a certain amount, because it's an incentive for doing that to make your office accessible. And then the small businesses have a tax credit that's available to them. So because of your ADA compliance, if you have to hire an interpreter, if you have to transition something to Braille so that it can be read by one of your clients, any expenses that you spend in order to be in compliance with the ADA, small businesses have the opportunity to claim some of that as a tax credit at the end of the year. Now, again, there are limitations on the amount of that, but it's just another incentive to encourage you to follow through with what's already required by the law to make your practice accessible and be a win-win for you and the public. Now I'm going to pass it over to Dave.
The next few slides aren't mine. Sorry.
No worries. How do we make our law offices and services more accessible to our clients? So first, we're going to be discussing how we can be proactive in considering accommodations. So when discussing accommodations, we have to consider the way the information is presented, whether that's text, pamphlets, or emails, and understanding how the way the information can be presented to be accessible, such as making sure that you have alternative formats, such as Braille, large print, or digital PDFs that are accessible to screen readers, and also making sure that there is different language that can be accessible to those who have cognitive disabilities. The second is the way an individual is required to respond, whether that's writing, speech, via email, via text. Some formats are more accessible. Some people may use alternative communication devices or may be nonverbal and need to use writing or other alternative formats. Some people may need to use speech. Some people may need to use writing. The way that we respond is very important. The characteristics of the setting is also important when thinking about accommodations, such as the noise or the lighting. Sometimes in lower lit situations, it can be hard for those with low vision to navigate those environments. So understanding how lighting, the brightness of the lighting can impact people's access. And the timing and scheduling of meetings, such as the time of day and length of meeting, that is usually done on a one-on-one basis, but it's important to think about accessibility from the social model of disability, understanding that there are outside barriers besides the individual's disability. There's the medical and the social model. The medical focuses more on the individual's disability itself. The social focus is more on the outside barriers that prevent access, which is what we mainly focus on. When discussing universal design and accommodations, the universal design principles from a broader perspective has 7 different principles for making information and tools accessible, which we can interweave when it comes to making our law offices more accessible. So these 7 include equitable use, which provides the same means of use for all of their users. So making sure it's universally accessible, making sure that there is flexibility in use, so providing choice in the methods of use. Simple and intuitive use, making sure that the use is intuitive, eliminating unnecessary complexity. The principal information, which is maximizing the legibility of essential information. Tolerance of error, providing fail-safe features and information. Low physical effort, which minimizes repetitive actions. And size and space of the approach and use, which is regarding physical access. So making sure that we have ramps and other information that can allow access to the building. When we're discussing legal accessibility specifically, there's a really great article called How Universal Design Principles Can Improve Legal Accessibility by Michael Isherl, which was published in 2018. And it describes legal accessibility as 3 core concepts, which is clarity, visibility, and structure when working with clients. And these are incredibly important regarding the implementation and making law accessible. These three concepts help to build a connection between the attorney and the client that they're working with. So through these concepts, an attorney would be able to convey legal knowledge and services to the greater public. And it also increases a client's speed and accuracy when making these important legal decisions. And so it's really important to think about how these 3, clarity, visibility, and structure, can demonstrate the attorney's mastery of the material and the law. The law itself is definitely really complicated. So making it accessible is really important to make sure that it can be generally appreciated and fully embraced. And we can attach the article later on to share the greater knowledge. It's multiple pages, but a lot of good information in there.
Okay, now it's my stuff. So I'm going to focus really on accommodation and accessibility for the deaf, hard of hearing, and deaf blind clients. That's really my area of expertise, but a lot of what I'm going to talk about, you could certainly apply to other populations as well, interpreters and accommodations and different types of accessibility technology. Go ahead and do the next slide. So I want to point out that, when we talk about a community, that can be a lot of different things. And when we use the term deaf can represent a lot of different things. And it's really important when we work with our clients to really understand, okay, well, when they're talking about themselves, or we're trying to figure out what types of accommodations may be needed, what perspective of culture, community, and language are they talking about? And again, you can see that there's the sort of the capital D deaf, which is sort of the community, somebody who identifies as deaf as part of culture. There's a lowercase deaf, which somebody might use as just to imply the condition that they're in, hard of hearing, deaf blind, late deaf, and oral, and all of these different populations. And by no means is this, an all-inclusive list, but these different populations or these different groups may need different types of accommodations based on their backgrounds, based on their area of language, based on their experiences. So we have to be very careful about assuming that just because somebody has a disability they fit into a specific category and it's one size fits all. You go to the next slide. And then along that same line, again, we talk about, the deaf, and so we have to get an interpreter. Well, keep in mind, there's a lot of different languages and communication modalities that a deaf person might use or a deaf blind person might use. So that's something that has to be considered as well. And as you can see, we have a lot of different types. There are some people that prefer speech reading or lip reading as opposed to using sign language at all. And not every deaf person uses sign language. In addition, there are other forms of sign communication. Now, I have American Sign Language highlighted in red because that's really the only language, and the rest of these are more communication modes. But again, it's important that you find out, well, what is the preference of your client? Because an ASL interpreter may not work very well for somebody that does the Rochester method or cued speech because it's not the same type of communication. So that's something you might want to consider. And again, it may be that you have to have an interpreter to kind of help you find out, well, what is the preference of my client? But it really is something where you have to know, okay, well, what is the language and communication preference that a client might have, and not just assume, well, if they're deaf, they sign, and if they sign, it must be American Sign Language. Next slide. So I sort of looked at the common language and communication accommodations, and really they can be put into two different categories. One is a sign language interpreter or interpreting service, and then the other is speech to text services. And again, some of this will depend on the size of the office, what are the ADA law requirements, what is available, what are the preferences of the person that needs the accommodation. Sign language interpreting services, a sign language interpreter is there to facilitate communication. And that's really all that the sign language interpreter should be doing. They're not really there to provide advice. They're not really there to provide information. They're not a consultant. They're not an advocate. They're simply there to provide communication or facilitate communication between a deaf and a hearing person. Again, we kind of talked about this can be done in a lot of different ways, American Sign Language, other forms of sign communication, or even oral transliteration if you have somebody that prefers, speech reading, lip reading. We also have tactile interpreters for clients that might be deaf and blind. And in this case, what will happen is the person will put their hand on the hand of the deaf person, so the deaf blind person, so that they can feel what the person is saying. And I just did the ABCs. So the deaf blind person would be able to feel tactile what the interpreter is signing. And then when they sign, they kind of switch so that the ASL interpreter can see what the person is signing and then, translate that into English. You also want to be aware of certified deaf interpreters. This is actually a deaf person, and the deaf person is trained to use their lived experiences, their knowledge of sign language, and then also deaf culture to convey concepts to lower nonverbal deaf individuals. You might have somebody, say, from another country that doesn't know American Sign Language. You might have somebody with some cognitive limitations or impairments that just doesn't have language. Somebody that just never learned language. They weren't in school, or they weren't around other deaf people, and they don't have any language ability whatsoever. A certified deaf interpreter would work with an ASL interpreter and be able to try to explain concepts through pantomime, through gesture, based on their knowledge and experience, which then they could communicate to an ASL interpreter, which the ASL interpreter would then communicate to English. And then same way, the person speaking English to the ASL interpreter, and then the CDI would figure out a way to make that concept clear to the low language deaf person. Speech to text services, STTSs, it's a term that's used to describe a lot of accommodations where spoken communication is translated into text in real time. Real-time closed captioning that we're hopefully is working today with Zoom would be a good example of that, where what is being said is just translated into captioning. If you think about your TV set and closed captioning, that's one of the forms of speech to text services. Again, there are a lot of different types. There's a lot of different ways that it's done. One thing to be careful of is that a lot of deaf people have very low English reading abilities because English is really a second language to ASL. And so your average deaf person has a reading level of about 5th grade. Doesn't mean deaf people can't learn to read at the college or medical level. It just means that that's your sort of average person or average grassroots deaf person. So again, be careful with speech to text services, because if you're translating speech into textual English, the person may not be able to read that unless they can read at a more sophisticated level. So different types, there's communication access real-time translation. also known as CART. That's probably the most popular one. It's the most well-known one. And that's where you just simply have somebody with you. And instead of interpreting into sign language, they're basically, listening to what the speaker is saying, typing that onto a computer, and then that computer is going onto a screen that the deaf person would read. And again, for somebody who's deaf and has some visual impairments, you can actually make bigger or smaller some of the text so people can see it easier. CPrint and Typewell are basically the same. They're just different companies or different ways of doing it. But generally, that's sort of real-time interpreting or real-time speech-to-text services. There's also remote types of services, and those are things that are done outside the actual meeting or event. So it could be something where you're working with somebody, and then remotely somebody is translating that into the language, and then they're typing it, and then it's going to the deaf person in your room, and they're reading it off a captioning screen, and then back and forth with that. Caption media is also pre-translated into text presentations. Again, that would be something like on your TV set that, a lot of times movies already are captioned or they're pre-captioned before they're aired on television. It could be something where there's a meeting where the speaker has their speech already, pre-translated into text or something like that. Generally, these are more informational types of things, because it's very difficult to pre-caption something like a speaker at an event or something like we're doing now, because we don't know exactly what we're going to say. But if it's just something like an infomercial or an informational presentation, that can be done ahead of time and then presented to the deaf person when they need that captioning. Next slide. So let's talk about interpreters. And again, the purpose of the interpreter is to provide effective communication. They're not really there to provide advice, advocacy, consultation, teach sign language. They're there to just really facilitate at the time communication between the deaf person and the hearing person. You want to make sure that your interpreter is qualified. Most of the time when you contract with an interpreting agency, they will have qualified interpreters, but that is something you may want to ask. Are your interpreters certified by the certified by the Registry of Interpreters for the Deaf? That's kind of like the organizational body that oversees interpreters in the United States. And that is something where we want to look at, is this something where the person is considered a nationally certified interpreter or a NIC certification? That means they have passed the standards of certification for the profession of interpreter and have been trained to provide not only the generalist type of interpreting, but they've also been trained in interpreter ethics and sometimes trained in specialties. Medical interpreting, legal interpreting, and educational interpreting are all specializations. Different states have different requirements, and I'm not going to get into that. If you're from a different state, you probably want to check your own state's requirements. But legal interpreters are often required by the justice system or the legal system if somebody is going to be interpreting in court. And again, the reason is the legal interpreter has specialist training in legal concepts, legal terminology, issues between, the ethics of, representing or advocating somebody as an attorney, and are better equipped and more knowledgeable of those things in order to provide a better service. In the same way, a medical interpreter would be trained or specialized in providing those, medical terms and medical interpreting between a doctor and a patient. So you want to make sure you get the right interpreter. You want to make sure they're certified. And for most of you, because this is an attorney type of presentation or of CLE, you're probably going to want to look into legal interpreting or somebody that has a legal background. And that would be something you would ask when you hire the interpreter from the agency that you're working with and make that clear to them. What is not a qualified interpreter, don't use staff that had a sign language class like 10, 15 years ago and, I can sign. That's not an interpreter. I mean, that's not somebody that really has the really depth of the language. If they're not certified, but it's a staff member or somebody that says, well, I know sign language, I took a couple of classes, do not use them, especially for legal cases. You're just setting yourself up for trouble. So just because somebody can sign does not mean they are a qualified sign language interpreter. Really should not use family members or any other invested or interested individuals, family members. You don't want to have children interpreting for their parents. You don't want to have parents interpreting for their children. Again, there could be a vested interest in that, especially think of domestic violence or child abuse cases. Do you really want the wife to be interpreting for the husband in a domestic violence case, or the child interpreting for the parent in a domestic abuse case? So be careful about using family members. Not all deaf family members sign. I mean, there are plenty of people out there that have deaf parents and they don't sign very well, and vice versa. So you have to be very careful about that. Police, I've even seen, there's been cases where in prisons, the prison staff have used inmates as interpreters. Again, a really bad idea. There's no confidentiality. It's even been cases where an inmate interpreter has put the deaf person at risk because they went out and told the rest of the prison population about this individual's crime. So you don't want to use inmates. Again, they don't have the ethical guidelines or borders. You don't really want to use other lawyers because, again, there's an interest there. There's some investment there. Other clients, other defendants, complainants. I mean, these are all people that shouldn't be used as interpreters, whether or not they have the skills, because there is an interest there and there is an investment with them. Writing back and forth on a keypad, a notepad, or texting is not the equivalent of using an interpreter. Imagine going to your doctor and trying to communicate to your doctor what your illness is, what your symptoms are, with just a pad of paper and a pencil. And then your doctor communicating back to you what you should do about it with just a pad of paper and a pencil. Would you feel you're getting all the information? Would you feel you're giving out all the information? And again, there's only so much you can do with pencil and paper. Gesturing and pantomime, that's not language. That's not really interpretation. Caveat to that, unless it's being done by a CDI who is trained on how to do that. But again, just gesturing to somebody, that's not the equivalent of sign language or interpreter. And speech or lip reading. Now, some people prefer that. And if somebody states, again, as attorneys, you want to get that statement. If they clearly state, I want to use oral method, I want to use speech reading, that's fine. I would probably get something in writing, but that would be something where you wouldn't have to provide an interpreter because it wouldn't be beneficial to them. If somebody doesn't know sign language, an interpreter is not going to be helpful. Next slide. So some of the assistive technology that you might want to think about in terms of your office or your workspace. Assistive technology is just there to help people function more independently. And we've got a lot of advancements. Technology only gets better. So we do have there are a lot of choices somebody can make that would make things like an office space more inclusive. Things are divided into things like alerting devices, might be a flashing alarm when somebody knocks on a door, or a flashing fire alarm. Could be a vibrating alarm, but these are things that you can help in your office. You can also, provide these things to clients to just help them live more independently. But again, it makes people aware of environmental sound. So somebody knocking at a door, a fire alarm, something like that, so that they're aware the sound is going on. There are also speech to text apps that you can download onto your phone. Some of these work better than others. The technology really isn't quite there yet, but it's something with you're having a short casual interaction, then you can probably do something with a speech to text app. I wouldn't use it for taking a deposition. I wouldn't use it for testifying. Again, the technology is not quite there, but more casual, informal conversations, it could probably work just fine. And it's a fairly simple, easy way to do things. Telephone devices, again, depending on the preferences of the client, you might want to use some type of ringer that can be attached to a telephone line. And again, some of these are higher pitched or lower pitched, depending on how much residual hearing the person have or might need. Amplified telephones. And again, there's a variety of devices that will, increase the volume of what the person is hearing or increase the speech level of what the person is saying. Caption telephones, or TTYs. You probably all heard the TTY before. These aren't really used anymore. I mean, the caption telephones and TTYs are dinosaurs, and nobody really uses them anymore because we now have video phones. And that's really the state-of-the-art way to communicate with somebody who's deaf or hard of hearing over a distance. They're easy to use. Different communications companies, Sorensen, for example, provides free video phones to anyone who's deaf. And basically what's happening is that I, as a deaf person, I would be signing through a camera to a video relay interpreter. That video relay interpreter would be on a headset and they would be speaking to you as the hearing person. And then you would speak, the video relay interpreter would sign it, and then I would see them signing on my computer screen. And that's how those work. The phones are already set up that way, so the numbers automatically know whether this is a captioned call or not. It's really interesting technology, but that is something that you want to think of, and then communicating through a video relay service is a much more effective way than, you know, the old teletype or TTY. Next slide. So I do want to talk a little bit about the do's and don'ts of, you know, working with somebody that, you know, again, from my perspective, we're focusing mostly on the deaf or hard of hearing. I love the Iron Man cartoon, and it goes something back to what Mira was saying about, you know, you want to really look at when you add this assistive technology, are you adding things, but they're, you know, you're adding things that are more distractive. So here's Iron Man who's learned to sign, but he has this light on his chest that's blinding the person, so I can't see what he's signing anyway. And again, you want to really be thinking about the makeup of the room. And you know, yes, I've got lights so people can see the signing or see the interpreter, but are the lights shining in the person's eyes so now I can't see them? Is the room set up so that the person can see the interpreter and work with the interpreter? So again, be careful about really kind of understanding what are the needs of the client. You know, make sure you ask clients their preferred communication method. I mean, that's an easy question to ask. I ask it all the time. I mean, I sign, you know, fluently, but when I meet with a client that I don't know, one of the first things I'll ask is, what is your preference for signing? Because it's an important question. I think we get a little nervous about asking somebody about, you know, their disability. I think we get very sensitive about that because we're afraid to say the wrong thing. But, you know, I mean, the deaf person knows they're deaf. I mean, you're not surprising them with anything. And it's a good question to ask. What do you prefer for communication so that I can accommodate your needs? Like I said, don't make assumptions about need and proficiencies. Find out, ask. Because if you hire an ASL interpreter for somebody that uses cued speech, you're kind of wasting everybody's time, and it's not going to help. When you work with an interpreter, speak directly to the client. Don't turn and look at the interpreter. In fact, some of the best advice I've ever given about using an interpreter is just ignore the interpreter. Just you know, act like they're not there. The interpreter should probably be sitting next to you with the deaf person sitting across so that the deaf person can see the interpreter. You don't need to look at the interpreter. The interpreter knows their job, and you know, just speak directly to the client. Don't use phrases like, well, tell him that, you know, tell him this. Just speak directly to the person. With the interpreter, if it's a good interpreter, what they're going to sign is tell him whatever you're saying. So they're going to actually sign the words tell him. And a lot of deaf people say, no, don't say tell him, just talk directly to me. So just talk directly to the client. Understand the role of their interpreter. Make sure you're not asking the interpreter for advice. Make sure you're not asking, unless it's language-based advice, but not asking advice on what the deaf person should do. They shouldn't be giving advice to the deaf person. That's not their role. That's not what they shouldn't be signing anything for the deaf person. They're not a guardian. They don't have any legal responsibilities to the deaf person except for communication. And it's always good to try to familiarize the interpreter with any relevant terms or issues. So again, depending on the case, you might want to meet with the interpreter ahead of time and make sure they kind of understand conceptually. You're talking about competency or criminal responsibility. Does the interpreter understand what those concepts mean so that they can kind of, you know, before having to do it, they get an idea of, okay, how am I going to interpret this so that it makes sense in ASL to the deaf client? You always want to go back and kind of assess your cultural competency. Does my training, does my experience allow me to work with this particular population or this particular individual? What are your own biases against people that have visual or hearing limitations, and addressing those biases and thinking about, are you doing something because you feel this person isn't capable of it? Is that the choice you're making because there's a bias underlying somewhere? Don't assume that all deaf people are the same, and we kind of, went all then, and deaf or visually impaired people are the same. It's okay to consult. You have my contact information. You have the contact information of Mira. I think we're fine with people contacting us to say, and this happens to me all the time. I have this deaf client. I'm in New Jersey. I don't know what to do with them. Can you help me? Can you talk me through it? Can you give me some advice? That's what really you should be doing, is recognizing what you don't know and getting help to make sure you're working in the best interest of the client. And next slide. I think we're almost done. Accommodations, again, just ask what's needed. Is this, before you go out and buy stuff, before you assume that this person's going to need a flashing light alarm, ask. It's okay to do that. Don't feel bad about that. Do you need this? Is this going to be helpful for you? And then try to provide it. again, the laws are very different. The ADA laws aren't meant to, destroy your business or be, too expensive. But it is something you should try to provide. And there are some places, and I have the links for you on where you can get some of these accessible types of accommodations. And again, you should always try to empower your client, that provide them resources, but let them do the homework, let them find the resources, help them with things that they may not understand, maybe some legal issues, but give resources that they can go out and look at themselves instead of deciding what resources the person needs. Make sure to inform and remind the client of what are their rights, but then also what are their choices, because ultimately they are a client and the choice is up to them. Sometimes clients make bad choices, but it's their choice to do so. As long as they understand their rights, as long as they understand what the choice is or what the choices are, they should be allowed to do that. And it's not really a good idea to make decisions for your client just because it's easier. And I've had that happen where people have said, well, if I want to make this, make my client or have my client make this decision, I'm going to have to tell them what it is or what the options are. I'll have to hire an interpreter or I have to have a special, that's just too much work. I'm just going to decide for them. Not something you should be doing. You owe it to your clients to allow them to make their own decisions that are going to affect them. Next slide. Oh, so this is just a collection of some of the resources I put together. I just, categorized them into, 3 different categories that you might find helpful. So again, different vendor lists for assistive technology that you can look at. Deaf in Government at the bottom is actually a site. They specialize in looking at people who work for state and federal government and what types of accommodations they might need, which ones are approved. So if you are working for the state, that might be a good one to kind of look at, but the rest of them are good too. National Deaf Center, NIH, video relay services. Again, the federal guides to communications. What does the federal government say about the laws pertaining to those things? Sorensen Relay is, I think, the 4th one down, but they're the one I mentioned before. But any of these are good and you can contact. And then different interpreting services. The Registry of Interpreters for the Deaf is the first one. Like I said, that's the professional organization. And that's a good one to just get information. They can also make referrals on their sites. They have different, RID approved interpreting agencies that they kind of recommend and suggest for different states and different areas. And then just some interpreting agencies that I'm familiar with, Keystone and Nationwide Interpreter Resource. Gallaudet University doesn't really provide interpreters, but they have a lot of good information on finding interpreters for, your particular location. And that's it for me. And again, like I said, please, if you ever have a client and, you want some consultation or you need some help, there's my email. So please don't hesitate to contact me. And I'm not sure if I'm turning it over to Alexis or Marilyn.
I'm happy to hop in. Folks, at least speaking for me, this is a really important training. I know that every single day in my practice and what I do, I'm always trying to, make sure that I am putting myself forward in a place of accommodating and better understanding. And this was just an amazing, amazing training. So thank you for opening the floor for this conversation, and thank you for giving us the tools to actually succeed in these accommodations. So I know, just want to mention up on the screen, like David said, you have contact information. All of our speakers are graciously saying you can contact them with your questions, so don't be shy. Take the opportunity, take the resources that you have. I know I will. I think I should have spoken more to Dr. Feldman before this training. I do want to go back and just mention the ASL interpreter did not join us today. I've been communicating with them. Apparently, there was an error with their scheduling team and they processed our request in the wrong time zone. So things happen, and I am very sorry. I want everyone on this webinar to know that all of our speakers, our co-hosts, our sponsors, Disability Rights Florida and PILS, wanted and expected an ASL interpreter. So really that falls on the company, but I will also, say it falls on me too, just because I will take that blame, and I'm very, very sorry. So with that being said, I don't think any questions came in through the chat. And before I do any last minute housekeeping announcements, was there anything else that our speakers wanted to say before we close out with the boring stuff?
I just wanted to hop in real quick, and I want to say Dr. Feldman brought up some really great points when it comes to assistive technology and working with clients specifically and making sure that you're building that environment. I think also another important perspective that we didn't touch on very much is the importance of if you wanted to hire somebody with a disability, what that process would look like. And making sure that you're making the office accessible. Like, per se, you wanted to hire a lawyer who has a low vision disability, how would you make sure that your computers and technology would be accessible to them? Would you need screen reading software? What would the costs and implications look like for that? So I think the importance of also understanding how disclosure works and also working on the flip side if you wanted to hire somebody with a disability. So I think that side is also important on understanding universal design is not just helpful for the clients themselves, but it's helpful for the entire nature of the law firm and making sure that we are building a more inclusive and diverse environment within the field of law as well.
I think that's an amazing point, Mira. And what it sounds like to me is another training.
Absolutely. Definitely.
And so, folks, please feel free while I do these last minute, housekeeping announcements to drop any last minute questions that you might have into the chat. But as I said earlier, this was co-sponsored by the Public Interest Law section of the Florida Bar, and our speakers curated and brought to us by Disability Rights Florida. The CLE application is still pending. As soon as I get that as soon as that process is finished and I get word that it is approved, I will follow up with each of you through mass email chain, be CCing you all, so don't worry, you'll get your privacy with that CLE code. My contact information is in the chats, but I think the closed captions might have been off when I originally said them out loud, so I'm going to do that again. My email address is Alexis, ALEXIS, .Alvarez, ALVAREZ, at Florida, FLORIDA, legal, LEGAL.org. And my phone number is 407-553-2075. Anybody that wants to follow up with me, please feel free. And I'm going to make sure that any closed captions that were not on at the time are manually entered before sending out this recording. So keep your eyes peeled. You'll get an email either from me or from Zoom with this information, but don't be shy. Feel free to bother me. I want to get you all of your resources. Anything else, Marilyn? Did you have anything you wanted to share? Dr. Feldman, no? Mira?
Oh, I just wanted to say right quick, I just saw in the Q&A portion, there was a quick question by AMC Bondoc, and I'm looking at the screen. It says, any tips on keeping accessibility in mind when transitioning to a paperless office? And I want to float that question to the larger group, see if anybody had anything that they wanted to add regarding that question. And if anybody has any other questions, feel free to put them in the chat or the Q&A portion of the on your screen as well.
Who wants to take it?
I would say the accommodation, the requirement to provide a reasonable accommodation is the same. It just might take a different form. If your particular client is requesting a hard copy and you're trying to do paperless, well, it would be reasonable to make an accommodation and an exception and provide the hard copy. So if you are transitioning to paperless, just know that you might have clients because of their disability that need to have a hard copy. And so providing that would be definitely an example of an inexpensive, reasonable accommodation that you could provide to that client. Dave, did you want to add to that?
Sorry, I was unmuting myself. No, I mean, I think you covered it pretty well. I can't think of anything that offhand that you would need to do differently transitioning from into a paperless system.
Definitely. I think those are all both really great points. I was thinking when it comes to paperless office, sometimes for me, like I have a low vision disability, I'm comfortable like disclosing that. So when getting PDFs and documents, sometimes they are just, they don't have optical character recognition technology. So when I put it into my screen reading software, it says, this is a blank image. There is no readable content. And so I can't access the document because it says there's nothing on there when I know there is. I'm like, I know there's stuff on there. So making sure, finding a way to make sure that there is optical character recognition on the software. Like if you're scanning in a book, making sure that you go through OCR technology. There's a couple of different softwares you can download that will do that for you. Or even I can see if I can look in and find any other resources, but that's the main issue that I've found is inaccessible PDF documents that are just images and don't have text when reading textbooks, or if it's a pamphlet, any information like that when it's like in a digital space is really important. And when it comes to a paperless office, if you have a website, making sure that it's screen readable. There's a section of the making sure it works with screen readers and is accessible in a variety of formats, making sure to follow good contrast rules. I know that there's a website accessibility law. I don't remember it I'm still learning. I'm still an undergraduate student, so I'm still in the process of learning that, but I can find that specific information that discusses website accessibility if anybody would be interested in that, or a list of good practices when it comes to accessibility in a digital space, because that's what we've been transitioning to, especially when it comes to COVID. So lots of new learning curves for sure. So
Absolutely. I think that would be great if you can send over those resources, because even me, it's something that I am still learning every single day in my practice, and it would help me even be more effective in what I do with marketing and webinars and communicating. So I think if I can benefit from it, I imagine out of the 100 people that we did have on, now 83, I think other folks can as well. And so I know another question came in through the chat about resource list. And so, yes, essentially, after we get off here today, I believe I'm going to be sent a copy of the PowerPoint, and that resource list is on that PowerPoint, and I will disseminate that to all folks who were here live, or anyone, even if they had to hop off early. And if Mira finds any other additional resources, I will make sure that I include those as well in that follow-up email. Like I've said a few times, the email initially, there will be one that comes from Zoom. It won't say my email address, but I've put my email address in the chat a few times, so please feel free to follow up. Anything else? All right. And so, with that being said, again, I apologize for the difficulties that we had on the technological side. Of course, in a subject matter as important like this is when something like that happens in one of my webinars. So I really appreciate all of your patience. And I also very much appreciate all of the speakers that we had here today. You are incredible, the work that you do, and just the ease and grace with which you share your knowledge. I can't tell you how invaluable that is for people like me and others who are really trying to learn, and just do the right thing as much as possible. So with that being said, folks, I'm going to turn off the recording, sign off, and hope that everybody else has a fantastic, fantastic day.